From the main list, item number 1.
Yes, sir. Yes.
Yes, Mr. Khan.
Lordship, I just started with my conclusion the other day, and the conclusion was the power of the High Court. So, Lordship, I'm just not to bother the court, Lordship, but the principles are laid down in very important judgment, 16, and just for perusal of the court. It starts from page 116, the last paragraph. Lord.
Just a second.
Page 116, Lordship, paragraph 16.
Yes. Yes.
No, may please, Your Lordship. Lordship, I will not delve further in this. The guidelines are very clear, except if some query comes, Your Lordship. Two fundamental things, Your Lordship, that comes up. Lordship first would be the legal issue of perversity, Your Lordship. Perversity by the trial court, whether the evidence, and broadly, Your Lordship, the trial court has framed 3 questions. So I'll just come straight, Your Lordship, to answer this question, where trial court has gone wrong. Page 586, Your Lordship, volume 2.
We'll find that in the volume 1.
Volume 2, page 586, Your Lordship. The Lordship has got it. 586, Your Lordship.
Yes, where does it begin?
It begins from last seen theory. It
576.
586, Your Lordship.
No, it begins at 576.
576. Your Lordship, yes. Begins at 576. Now, let us see how the court has dealt with the last seen theory.
Last one, 33, 23, 20. I have to think it's 56. It will be able to cover completely. So, what is PWC history? Is 40. 25 is 25 is 33 is 40. Cameraman, PC.
Yes.
Lordship, there are major infirmity in terms of not appreciating the evidence, if I may clarify, Lordship. In consideration of the evidence, the trial court has relied on PW1 and heavily on PW6. And that is the starting point. And Your Lordship, it delves further, then it takes the evidence of PW12, page 588. It discusses PW12 in cross-examination. At page 589, Your Lordship, PW17 and 590, Your Lordship, PW22 and 33. And it comes to its conclusion at page 591. So these are the evidence that was considered. And the finding, Your Lordship, is at page 594, para 46. It starts from para 46, 594. 46, 47, 48.
But then before 597 is actually before that. 597 is probably before that.
Yes.
May it please, Your Lordship. Lordship, the finding on last seen theory is specifically at the para 48, page 595. This is 3 line only, Your Lordship. Therefore, in view of the above observation, this court is of the view that the prosecution has not been able to prove the accused was last seen with victim at 8 p.m. at Mauro. Now, Your Lordship, admittedly, if I may submit, Your Lordship, the prosecution then they had also misdirected itself in taking out the main evidence. Now, we have come, Your Lordship, on reappreciation of evidence before the trial court, we have come to an important inference, Your Lordship, that the last seen theory starts, it may have started from Police Bazaar, what PW 1, 2, 3 and said. But the crucial point was when it stems from the confession made by, not confession, sorry, Lordship, an admitted statement made by both the accused where they were seen together. This part of the evidence, Lordship, has been grossly overlooked. Neither it is discussed nor appreciated.
Yes.
Your Lordship, I will not try to elaborate further because we have already argued at length. If this part of the evidence which was existing before the trial court and it has overlooked, not discussed, it's a clear case of court misdirecting itself in arriving that this is not a last seen theory. Number one, Your Lordship. Number two, Your Lordship, we'll go to page 597. Page 197, Your Lordship, is this prosecution also relied on the recovery of dead body of the victim and the rope murder weapon.
Excuse me.
Lordship, to answer this important query, the trial court has directed itself in appreciation of witness of PW1, PW20, PW30, PW31. Lordship, I'll come back to 31. 31 is very relevant for our purpose. PW 32, 33. 31 and 33 is important, Your Lordship. Of course, 31 stands on its own. He stands on his own footing, being an independent witness. I'll just come to it later on, Your Lordship. 33. Yes. And then, Lordship, he's answered both the question together. And then we come at 602. First was recovery of dead body. Second is he directs himself to also address the issue of recovery of rope, which is at 602.
CMS PW11.
Lordship.
IO?
33, Lordship.
IO is 33.
33.
CM is 34.
CM is 30.
PCM would be at
30.
34.
He is the IO, no?
He's
Second.
they are
Second
two
IO.
IOs, 33.
So 33 and 34 are both IOs.
Initially, Lordship, the investigation was carried out by P33, and then subsequently it was done by 34.
Yeah. That's all.
May it please your lordship. One more, your lordship. Page 608, your lordship. 608. It's the third issue.
608.
8. The court was addressing the issue of confessional statement, your lordship.
We've gone through that.
No, absolutely, your lordship. So I'm just saying this totally misdirected purpose. And, your lordship, before I conclude, your lordship, lordship, I'm relying on para 27 of this judgment. Very important proposition of law.
Just a second. Paragraph
27, Your Lordship. Page 12. Page 12. Page runs in the bottom right side, Your Lordship. Three important aspects is there, Your Lordship, in this particular paragraph. Lordship, with the leave of the court, I can just bring to the knowledge three important aspects has been discussed in this paragraph. First is the admission of the appellant, which is similar in this case. Second, Your Lordship, no explanation. And third, the medical report with belies.
So you've cited 4 cases, 2005 7 SCC on section 8 and 27,
Lordship.
78 4 SCC on IO's evidence being, and today you cited circumstantial evidence, Justice Manoj Mukherjee's judgment and the unreported judgment. Very good. Yes.
Oblige, Lord.
Who is Bonnie? You are Bonnie.
Yes, my lord.
Bonnie is, they spell it as Bonnie, B-O-N-E-Y.
N-E-Y.
Bonnie Fawa Lingdo.
Bino Boni Lingdo Hawa.
Yes.
My lord, first of all, I would like to draw your lordship's attention to the missing report, which is at page 1
What report?
of the FIR, my lord. It was filed as a missing report and subsequently registered as an FIR.
Yes.
Page 1 of volume 1, my lord.
So you intend to cover page by page from page 1 to page
No, my
600?
lord. No, my lord. Since the prosecution has been harping mainly on the last seen theory, that is why, my lord, this FIR is a very, very important document which needs to be
It's
brought.
utterly irrelevant.
My lord. Page 1. There's no index, my lord, so it is the first page. My lord, before I read, if I may point out the reason behind reading out the FIR, is because this points out from where the last seen theory started. I would like to bring to your notice that Shri Biplab Das, son of Shri Binoy Das, resident of Shiv Mandir Siliguri, and now residing at Dossier Lodge, Lower Lashumyar, and a student of second year mass communication, has been missing from 8 p.m. of 18th December 2006. Reportedly, he was last seen in Police Bazaar with a friend by the name of Bernard. A brief description of the missing person is as follows. Name Biplab Das alias Paplu. Age, height, color of hair, clothes. And I shall be most grateful if your department can trace the person at the earliest. My lord, this missing report was lodged by PW1. So PW1 is one of the most important witnesses in this in the instant case. Now, my lord, how did PW1 come to know about the missing of Biplab?
See, we are wasting time.
My lord, okay, I'll point out
Could have been
only.
an Akashvani that
No,
but
my
it's
lord.
utterly irrelevant.
It's not an
We
Akashvani.
have told you the starting point is the confession, the ending point is the confession. What everyone has said in between is rubbish.
My lord, before that, there is one more important aspect. There is an exhibit which was placed by my learned senior last week. That is Exhibit 1 by 1, which was the PCO call made. Exhibit 1.
One by one.
Exhibit 1, sorry, my lord. Exhibit 1 was the record of the PCO call made to PW6, allegedly made by the victim.
Yes.
Now, my lord, if your lordship kindly takes up page number 409 of volume 2.
What is the point that you're trying to make
Point
now?
out here, my lord, is in the statement made by PW1, he says that he handed over this PCO receipt on 22nd February. The seizure list is dated 20th February. One witness has signed and put the date of 20 February, whereas the second witness, who is also a friend of the victim, has put the signature 25/4/2006, which means, my lord, he was not present at the time of the seizure being made. So, my lord, this document itself is a tampered document because the signature of the witness, either one of the witnesses has signed it backdated, or else the other witness has signed it subsequently after 2 months of the seizure being made. Page number 409.
Where have you questioned this before the trial court?
My lord, probably it might not have been questioned.
All of this was given to you under 207.
Seizure list, yes, my lord, it was provided
All of
along
them?
with it, along with the charge
Which
sheet.
witness has referred to this seizure list?
This seizure list, my lord, Exhibit 3. My lord, Roger has cited, my lord. PW 17.
And what is your cross-examination of PW 17? Where is the evidence of PW 17?
My lord. PW 17, my lord, it starts at page number
You're dealing
235.
with Exhibit 1.
Exhibit 3.
Exhibit 3. What is the exhibit? It's a seizure list
Seizure list of the PCO call record.
of PCO
Call record.
call record.
There are two witnesses to this, my lord. The PW 17 starts at page 235, volume 1. And this is not something which the police had seized directly from the PCO owner.
Please remember, madam,
My lord.
all the bad points that you make
My lord.
and we discard
My lord.
is a nail in your coffin.
My lord, I get
It's
that.
not the last nail, but all the bad points that you make and that we discard are all nails in your coffin.
Indeed.
Does the PCO record look like a PCO record? Is it in order? After that, if the investigation has botched it up, or if someone has signed a wrong date, what is the relevance of that? Does it look like a PCO record? It looks like a PCO record. Does it have printed things on everything? Yes, it does. Does the printing in the relevant record appear to be fabricated? No, it does not. So who signs it when, who says about it is irrelevant unless you have brought it to the notice.
That
Number one. Number two, this is not a ground on which the trial court let you off.
My lord, the
So
ground.
why are you going on a ground which is not there, which is not one of the grounds on which you were let off?
My lord, then I will not waste your lordship's time. My lord, I will stand by one of the most
You have
important
to
grounds.
sustain the judgment.
My lord,
You have to sustain the judgment on the grounds indicated in the judgment.
my lord.
You may refer to other material, very crucial, but which the trial court failed to look into.
My lord.
Provided you had brought it to the notice of the trial court, you can't concoct a new argument today by looking at it.
My lord, then
Your cross-examination of those witnesses don't demonstrate questioning of the veracity of the serial list or the document.
that's the difference between, my lord, because I have been engaged in this matter only.
We are not concerned.
My lord.
You are repeating ad nauseum that the trial court lawyer was a buffoon.
No,
Does not improve the
at
matter.
all. Not at all, my lord.
That's the purport of what you're saying.
No, my lord.
That look, I'm so good with the trial court lawyer.
Not at all, my lord.
Why you
And
think that?
myself also, my lord, I
Then
can
why you
never say
think
that
that?
I'm
We are aware as to your status.
obliged, my lord. Now, my lord, the post-mortem, my lord. The post-mortem was considered by
First,
your
tell
lordships.
us what are your points, weigh, and then we'll record it in that. And if we see that there is a possibility of any other theory
My lord,
inconsistent with
my lord.
the guilt of the accused, then we have to accept that theory. So you tell us your points which will show that it is possible
My lord.
that something else may have happened. Once you do so much, you have very little thing to do.
Benefit of doubt.
Once you show that this was a possibility, if there is a possibility, then we cannot say that it has been proved beyond reasonable doubt.
My lord, PW6, Nirvika Singhania, in her deposition before the learned trial court,
Again, you are going on to, we have concentrated on the two
confessional
statements.
statements, my
The two
lord.
statements, we are not calling them confession, we are calling them 164 statements.
164 statements.
We are not giving them any names.
My lord.
Your client is now has sought retract
My lord, I can.
in his 313 without any cross-examination to that effect.
My lord, in
And the only anomaly that can be pointed out is as to the date, which is irrelevant. We will take that on record
not
and say,
just the date, my lord, if I may submit. If your lordship kindly takes up the statements of the two accused persons recorded under 164.
yes. The other thing that you can do, madam, is to tell us a story.
My lord,
Tell us a story.
that is what I'm coming to.
Yes, tell us a story which leads us away from your clients.
My lord, page number 12.
Yes.
Page number 12 is the 164 statement recorded of Bonnie.
Page number 12.
That is the original copy, my lord.
Look at the type one.
Now, my lord, I would like to make a distinction between what the same magistrate has done with regard to the two accused persons, which is highly relevant, my lord, in light of the answer given by my client before in his statement under section 313.
Yes.
We take page 12 along with page 25, a
Well,
comparison.
yes.
If your lordship has got 10:30 a.m., my lord,
Section 164, Pony is 12, Bernard
25.
25. Yes.
Now, my lord, if your lordship sees at page 12 and 10:30 a.m. to have his confession recorded, the letter or memo given to me dated. In Bonnie's case, my lord, it is blank.
Yes.
Whereas if we see in Bernard's case at page 25, it clearly says 7/3/2006.
Yes.
First distinction, my lord. Now, my lord, coming to
How does it have any impact?
impact, my lord, because under the 313 statement was recorded in a question answer form. And PW 32 was also examined. PW 32 is the magistrate. In 313, at question number 15, when the question was put to the accused, Bonnie, as to the statement recorded by the magistrate, he categorically made a statement that he was brought to the courtroom, he was made to sit from morning till evening, but no statement, was recorded.
Ultimately, she wrote something, signed and
discharged.
Now, very good.
Now, my lord.
Now, why did Bonnie sign that statement?
My lord, being a layman sitting
Why did
inside
Bonnie
a
sign
courtroom.
that statement?
My lord, being a layman sitting inside a
I'm going to
courtroom.
accept that.
Sitting
Why
inside a
did Bonnie
courtroom.
sign that statement?
My lord,
He was silent the whole day. Maybe that day, next day, 2 days later, he was given to sign something.
only on that day, my lord.
Only on that day. Very good. So therefore, the discrepancy in date goes.
There is a discrepancy, my lord. Because
the
today,
you cannot say in the same breath. If he went,
Coming to the
waited the
second
whole
part.
day and was made to sign on that day, then the discrepancy in date is irrelevant.
discrepancy is relevant, my lord. Why? Because 9th March, it says that the magistrate has recorded the statement. According to the
When
magistrate,
did Bonnie sign it?
8th.
Then
And my lord, regarding 9th, I had a telephonic conversation with him today itself, and he's saying on that particular relevant date, he was under
and
medical
then you'll have
treatment.
to take off your jacket and band and get into the box.
My lord,
If you're going to talk of telephone conversation with your
Instruction.
client, then you have to get into the witness box.
my lord, I am.
Keep that apart.
my-
You're not children over here.
I keep that apart.
You're not children over here.
My-
You're hardcore lawyers. So that kind of drama does not evoke any sympathy.
I'm not
If you want to
being
give
sympathetic, my
evidence,
lord.
get into the box.
My lord, I not at all want to
So
be sympathetic.
why do you mention you talked to your client on the phone today? What are you trying to impress us with?
I'm not impressed, my lord. I'm not trying to impress, my lord. The only thing is, after studying the case, I just wanted to know what is his side. Because 313 is clear to some extent, but not extremely clear. So I wanted to know further if there is anything that he
Yes,
has.
tell us what is there.
My lord, first thing is the date on this particular page. My lord, a magistrate does the same thing the previous day. The next day, she will not make a mistake. We can be 100% sure about that. On 7th March, she has categorically written the memo date at page 25. But when it comes to Bonnie, there is no mention of date. The same thing has not only happened at this page, it has happened at page number 14 also, my lord. If your lordship will kindly take up page 14. Page 14, my lord. At the bottom, signature of magistrate. No date has been put, my lord. Now coming to the same...
Just a second.
Sorry, my lord. Apologies. The comparison of page 14 is at page 27 with regard to Bernard. Signature along with date is there, my lord.
Yes. But will you come back to page 26?
Yes, my lord. Page 26, there is no date, my lord. The same is with page 13 as well.
Yes. So therefore,
And my lord, there is
the
one
magistrate is given
more,
to this kind of carelessness.
my lord, one more aspect. If I may take your lordships to page number 18.
Yes.
Page 18, my lord, at the last paragraph, the statement of the accused Bonnie Lingdop, however, was recorded by me. The same was read over to the named accused and admitted by him to be correct and contains a full and true account of the statement made by him. Now, my lord, in Bonnie's case, the signature is on the side of the page, on the left-hand side corner. Whereas, my lord, if we take the same thing with regard to Bernard, it is at page 32.
Yes.
Page 32, my lord, the same thing has been written, the meaning, in the meaning sense, I mean to say, the same thing has been written, but the accused person's signature has been taken at the bottom, my lord, not on the side. Side only in block letters it is mentioned, my lord. The
Where
signature
is
is at
the
the
accused
bottom.
person's signature at 32?
My lord, down below.
At 32, down below where, madam?
No, just above the seal of additional district and sessions judge, exhibit number so and so, and it's a roundabout, my lord. That appears to be the signature of Bernard. To my understanding, my lord.
There is a signature of the magistrate that we see with the date 7306.
Yes, my lord, that is above.
That is the magistrate's.
Yes, my lord, right at the top.
Yes, on the right hand side.
Yes, my lord.
Where is Bernard's?
My lord, this just a round circle and then a stroke.
Round circle, not a square
Roundabout
circle.
means from the top around and then a stroke, my lord. Between exhibit, where it is mentioned, exhibit 19.1.
Yes, just above that. That cannot be because that is
No,
a
my lord, the
signature.
above one is
25.
additional district and sessions judge.
Yes, because the two are same. Additional district and sections, there are two stamps.
But then there are three signatures, my lord.
Where do you see the third signature, madam? Do you find the third signature there? Oh, right at the bottom.
Yes, my lord. There are three signatures
But
after the magistrate.
Bernard's signature, let us see Bernard's signature anywhere else.
Should we come to page
Page 27, my lord. It's he has written his full name
Yes.
at page 27.
And there's no other signature of Bernard.
No, my lord.
There is some signature of Bernard in some other document. I remember having seen that.
Dead body seizure list.
Exhibit
in the inquest.
Exhibit. Inquest, the exhumation was done.
So what here you see,
400.
Bernard also has not put a date.
Bernard has not put his date, my lord. But Bonnie has
Where
put
is
his
the
date.
document, Mr.
Lordship, may kindly have
411.
412, my lord, of volume 2. Page 412. The second page of the inquest report.
The second signature,
412?
bottom, signature of accused person,
Yes. 21-2.
my lord.
Yes, I marked it as Bernard's signature.
Yes, my lord.
But this signature which you attribute to Bernard, 32, there is no resemblance to the signature at 417, at 412, 417. Does it? It bears no resemblance. Is there no other signature of Bernard anywhere?
Lord,
There
inquest
is
report.
some signature of Bernard
Inquest report, my lord. Apart from inquest, no. So, my lord, in this case, Bonnie's signature has been taken on the left-hand side of the.
How does it matter wherever
My
you
lord, we
sign?
don't. My lord, since he is stating that his statement was not taken, he was
As he
merely
said, I
made
have
to
not
sign.
signed.
He was merely made to sign.
As he said, I was made to sign.
Yes, my lord. Question number 15, my lord.
Made to sign on what?
My lord, I'll just read out the exact statement that
Yes.
he has used. 15. I was actually, my lord, this 313 was recorded in Hindi. I'm reading in English.
Let us read the statement.
I was produced before the magistrate who asked me, and I have stated that I want to confess the truth. Then I was kept there in the courtroom for very long time, and when it was to get dark, the magistrate asked me to sign on a paper and thereafter reply me to go. And I did not get to tell or confess anything at all. It is a clear and categorical statement, my lord.
Very good. What is the clear and what is the
That
clarity?
I did not get to tell or confess anything
Right.
at all.
Now, where did he question the magistrate? Where did he say I signed a blank paper? Read the entire cross-examination without
Yes, my lord.
cross-examination of Boni.
Page number 317, my lord.
Yes.
Crossed by Boni.
Yes.
I do not remember whether Exhibit 4, the inquest report, was prepared in my presence. In Exhibit 4, my signature is appearing as a witness, and Exhibit 4 by D is my
Where is his signature as a witness?
signatures, my lord, in the exhibits.
Exhibit 4, yes.
Exhibit 4 is at page 411, my lord.
417 also.
412, 413 is Exhibit 4.
412, 413.
Yes, my lord.
Just
The signature is at 412.
signature is at 412.
2.
Yeah, we've seen 412.
412, the first one is the signature of the magistrate, my lord.
After that, number 2 is Bonnie's signature.
No, my lord.
Which one is Bonnie's signature?
Bonnie's signature is not here, my lord.
Then
Bernard's signature is
we
here.
are asking about Bonnie. Bonnie says
No, this is
question
the
15.
statement.
Question 15 that you read out was Bonnie's.
Yes, my lord.
Now, what is Bonnie's cross-examination of the magistrate?
Yes, my lord. I'm reading the cross only.
Yes.
I do not remember. This is the statement given by the magistrate.
I want signature
cross, my
to
lord.
Bonnie's cross-examination. Yes.
Bonnie's cross. That is what I'm
Yes.
reading, my lord. I do not remember whether Exhibit 4, the inquest report, was prepared in my presence. In Exhibit 4, my signature is appearing as a witness, and Exhibit 4D is my signature. I do not agree that, as I am a witness to Exhibit 4, I am not competent to record the statement of the witnesses or even that of the accused persons in this case. I agree that as a witness to Exhibit 4, I am substantially aware of the facts and circumstances of the case. At the time of holding of the inquest of the dead body of the deceased, only one accused is present, and that is accused Shri Bernard Lingdorp Hawa. I cannot remember now exactly. Witness then says that Exhibit 4 was prepared on the spot. I do not know any of the witnesses personally in this case whose statement I have recorded. No one has identified the said witnesses to me, but the witnesses themselves identify themselves to me at the time of recording their statement. It is correct that Exhibit 20 confessional statement of accused Bonnie was recorded on 9/3/2006. This is the statement of the magistrate.
Yes, very well. Then
on being shown the order sheet of the case record today, I say that there is no order dated 9/3/2006. It is not correct to say that in the statement Exhibit 20 of accused Bonnie Lyngdoh Hawa, I have incorporated my own knowledge of the case in a later date. It is also not a fact that Exhibit 20 is not the correct version of the accused person. It is correct that Exhibit 20 reflects the signature of the accused with a date thereon as 8/3/2006. So, my lord, the question was categorically put to the magistrate as regards the incorporation of some other material on a subsequent date, because the signature of the magistrate is 9/3/2006.
No such question.
And in the statement also, she is stating that I recorded the statement of 9/3/2006.
Yeah, that's a mistake. That's a mistake. We take it as it requires an explanation. There is a suitable explanation. It does not alter the quality of the statement recorded or its veracity. No.
And so far as PW6 is concerned, my lord, why I am
PW6. Now, what is the point that you're trying to make? Whenever you're trying to make a point, just tell us.
Before reading, I will tell the point, my lord.
Yes.
PW6, my lord, why I am stressing on PW6?
So, are you through with the magistrate?
Magistrate, my lord, for the time being, I think that is my submission.
Very well. So, statement under section 164. Now, Nirvika.
Now, my lord,
Nirvika Singhania.
Nirvika Singhania. My lord, Nirvika Singhania.
Girlfriend or alleged wife of the victim.
My lord.
PW6.
PW6.
Yes.
Lord, the point which I am trying to make out here is,
He referred to Sylvie Fell.
she
also referred to Sumit.
she was the person who told Roger that Bernard and the victim, Biplab, they were last seen together in Police Bazaar. Whereas the deposition says that she was only informed earlier that Biplab was supposed to meet Bernard in Police Bazaar. Whereas at around 8:30,
We disbelieve all of that.
At around 8:30,
We disbelieve all of that.
my lord, but Sumit has nowhere been examined.
May not have been. We disbelieve all of that. But how does it have any effect? Nirvika, maximum what appears is that there was a phone call made from that PCO, and that phone call was made to Nirvika's phone. Nirvika spoke to probably Biplab at that point of time.
My lord.
So, whether anyone was seen with Biplab at that time or not, Nirvika cannot have any knowledge of that.
Yes,
What
my lord.
her knowledge would be hearsay,
Hearsay knowledge.
which we will disregard, just as we disregard the FIR maker's allegation reportedly seen with. Reportedly seen with means hearsay, he does not have knowledge, he does not give any evidence to that effect.
My lord.
So all of that goes.
All of that goes, my lord.
Only what remains is the 164 statements.
My lord, but I'll try to satisfy your lordship on 164. But my lord, regarding the post-mortem, on a previous occasion, your lordship had stated that since it was the month of February, it was still cold out here, and that is why we will stretch 48 hours to maybe 96 hours also. But my lord, had it been a case that the death took place in Shillong and the post-mortem was carried out in Guwahati, then my lord, we could have contemplated that. Reason being, my lord, the doctors out there would be of the mind of the climatic conditions
We
there.
are not on the inaccurate approximation by a doctor,
But my lord,
not familiar with the place. We are on firmer ground. We are on the firm ground that when the temperature is colder, the ability to approximate will be less because the preservation of the body is much more.
But my lord, the doctor out here was an experienced doctor
May have been. You can make
for
an
a number
argument on that, but it
for a
will
number
not.
of years.
You can make an argument on that, and we'll have to record it also, but it will cut no ice with us.
But it was an experienced doctor.
Very good, very good. Don't jump from Nirvika to the doctor. This is what we hate.
My lord, because
You finish your point with
My
Nirvika.
lord, your lordship just stated that we cut off Nirvika. Nirvika we are not taking into
So therefore,
consideration.
now make your next point and then go there. So the next point you're making is the
On the postmortem.
postmortem report. So Nirvika over. You will not refer to her. Very good. Now postmortem.
Because lordship has already set aside the evidence that has been given by her.
Irrelevant, except the fact that Biplab probably called her,
My lord,
and except
calling
to
is
the
there.
extent that she confirms that it was Biplab. And she would be familiar enough with the voice.
My lord, she has confirmed in her evidence.
So very good. So we take that. But as to who was with Biplab, nothing that she says matters to us.
As your lordship pleases.
So we will not count that against you at all. That she says that Bernard may have been or something.
My lord,
We will not get taken into account. So now you are on postmortem.
PW2.
And PW2, you say experienced doctor. You say says about 48 hours.
Yes, my lord. 48
That will
hours.
take to 28.
To
That is 20th of February.
Yes, my lord.
The year was 2006.
2006.
Cannot be 96 hours, 18th of February. That is your argument. Yes.
That is my argument, and I sum up on that.
If you have anything more scientific on that, you can do it.
My lord, on the postmortem, so far as
Right? You
medical
should have got some
jurisprudence-
medical jurisprudence to show
Medical-
what is the extent of approximation. You could have demonstrated that on the basis of some medical jurisprudence, that when the approximation is 48, it can be taken up to 24, or 48, it
Maybe
can be
72.
taken up to 12 hours more. It can never be taken up to 48 hours more. If you had shown something like that, then that would have given you,
weightage.
instead of concentrating on
Lord, since
how
your
the
lordship
date is
was in
written on
fact-
one page, how the date is written on another page. Yes.
Now, my lord, the next thing, my lord, PW18, my learned senior has already referred to.
Who is PW18?
PW18 is the driver of Pasture Beat House, and he is reported to be the rope seizure witness.
We don't take the rope into account. We don't take the rope into account. We go no murder weapon discovered.
My lord, then on
murder weapon discovered.
PW18, then my lord, I will not waste your lordship's precious time.
You can proceed on the basis of no. It cannot be said with any degree of confession that the murder weapon was recovered at the behest of either accused, or that was indeed the murder weapon.
My lord, on both counts, the first count is rope. The prosecution is saying that my client, Bonnie had led them to the rope.
We are not
That
satisfied.
is not at all,
We are not satisfied. That was the case.
because my lord, on 21st, the body was exhumed from the same graveyard. So if the body is being exhumed on the 21st, will the police not look about the whereabouts after seeing that there is a strangulation mark on the neck? They should have. Most probably that has not been done.
What time was it on the 21st when the body was exhumed?
Body was exhumed at around 11 a.m. if I'm not.
It was evening. Cameraman says so.
Three PM.
3 p.m. So February, my lord, it would not be that dark.
Not that.
So, my lord, they have neither tried to make any search, and as
Anyway, you tell us PW18, go make this point.
my lord, why I am on PW18 is, my lord, he
Who is PW18?
is one of the seizure witness of the rope.
He is the first of
Police. He is the driver of the police station.
police driver. rope seizure witness.
Now, my lord, when we talk about,
Where is the page?
my lord, PW 18 is at page 247.
247.
Now, my lord, when we talk about rope seizure witness, I will be relying on 4 witnesses. First is PW 18, then comes PW 25,
And 31, 33.
26,
And
my lord, the IO, it will be 33 or 34. It is 33, my lord, because it was in the month of February,
yes.
as stated.
Yes.
Now, my lord, PW 18, if I may read the cross-examination of PW 18, my lord. By Bonnie. I'm a permanent...
Just a second. What does he say in the thing?
Yes, my lord. My lord, this entire cross is important. It's a very short one.
We'll first see his chief.
Chief, my lord. Chief, he says, I have received someone to depose in court today.
Forget all that. Come to the material part.
I am a driver by profession since the last 10 years. And now I am a driver at Pasture Beach.
Again, you're reading that. Come to the material part where he sees what he...
On 18 December 2006, my lord. The rope is said to have
Very
been
good. That's a good point. 18th December.
2006.
Yes.
I was on my duty at the Pasture Beat House, Shillong. On that day, that is 18/12/2006, the OC of Shillong Sadar PS, along with some escorts, came to the Pasture Beat House, where I have seen that they were having some discussion in the office chamber of the in-charge Pasture Beat House. I was present outside the room chamber of the in-charge Pasture Beat House. After some time, I was directed by my supervisor to the place of occurrence, where I was the driver of the sumo car, being registration number ML05C5588. The occupants of the said sumo car were the... Lord, this is very, very important. The occupants of the said sumo car were the in charge of Pasture Beat House with some police constables and the OC Sadar Shillong police station and some constables. My lord, there is no mention of Boni being in the vehicle. They say that the rope was seized at the behest of Boni. So there is no mention of Boni in the statement of PW 18. In the said sumo car which I was driving, only SIS GS Gill and in charge HM Slong. Other vehicles were then following us were the OC Sadar PS and staff were present from the Pasture Beat House. We left towards Golf Link at a place where cremation stands. It took about 10 minutes for me and my officers to reach the said cremation ground. On reaching
This is nothing. This is...
Yes, my lord. Now coming to the cross, my lord.
Nothing against you.
My lord, the material part...
This is nothing against you.
Yes, my lord. It is nothing against
false
you.
evidence.
My lord, will kindly see the cross once. He again states, I am a permanent driver of the so-and-so.
Yes.
After that, my lord.
We will not take any inference against you on the basis of this evidence.
Then, my lord, I
This is completely disregard.
25...
Then come to PW 18.
This was
PW
18, my
25.
My lord, PW 25 is at page 283. But my lord, since your lordship is saying that the murder weapon is being disregarded, the rope is being disregarded as a murder weapon.
Let us see what you have to say. We might find something relevant to point your guilt from what you say. PW 25.
My lord, 25 has already been referred to,
Page
and it says
283.
the same thing.
Just a second. Yes. Completely contradicts him, says 24th of February.
Yes, my lord.
One is 18th of December, 24th February. These are our previous notes we date. I went to the PO along with Bonifawa. Bonifawa was not mentioned by a thing. On being shown, I identified Bonifawa has not recorded any statement. Also, I was not recorded the statement of the accused before recovery. Nearby are residents or others, but I was not made any attempt. After recovery, kept and sealed. I has not taken my signature. Sealing, there is no specific. It is not a fact that. Well, that's only because over here. Why was that question asked to him? If you come, madam, to page 283, he does not say Bonifawa led. He said, I went to PO along with Bonifawa. Oh, on arrival, on being led by the accused. On arrival, on being led by accused. We completely disbelieve this.
25 says the same thing and 26 also says the same thing, Malad.
26, let us see.
At page 295.
At page 295. Same thing, it does not appear very convincing to us. PW 33.
My lord, PW 33, my lord, if your lordship permits, I may be permitted to read the cross of the IO completely.
We will do that, but let us finish the rope first and then we'll go to the rest of it. What does it say about the rope? Page 33?
At page 324.
At page 324. Is regarding the rope.
Regarding the rope, my lord.
Thereafter, you read it out to your heart's content. Both incompetent and completely unaware of how to conduct an investigation.
7th line from the bottom, my lord, page 324.
I did not record statement of leading to the discovery under section 27.
For seizure of material exhibit rope, which was recovered on the leading of the accused, the witnesses reflected in material exhibit 16 with regard to seizure of material exhibit 2 are all police personals except for one Shri Deepak Das, PW 18, who was the driver of a vehicle requisitioned by the police on that day. I have not recorded the statement of these witnesses of exhibit 16.
Very good. Yes, we got that. Yes. Now, next point. So what has happened? Therefore, we are.
Now, my lord, coming to the cross-examination of both the investigating officers, since there are two. Lord, I start with page 324. This is the cross of.
Just a second. IO, PW 33.
And 34.
Cross-examination. Page 324.
My lord.
Yes.
Exhibit 2 is the missing information report lodged by PW1. The missing person died on 18th February 2006. If I may pause here for a moment, my lord. My humble submission still remains
yes, absolutely.
that the date of death is not 18th
Absolutely.
February.
He does not substantiate it. Absolutely.
The case was registered by Shillong Sadar PS under section 364A IPC. It was in course of investigation that it was revealed that the kidnapping was for ransom. The accused Shri Bernard Lingdorp Hawa was picked up for questioning on 19th February 2006 and he was arrested on 20th February 2006. Before his arrest, Bernard Hawa had given the sequence of the offence. I cannot say from which phone a call was made to the mobile phone of the deceased father, PW5, demanding ransom. I did not seize the mobile phone of PW5 to reflect that a call has been made to this number demanding ransom. I have seized an auto rickshaw wide Exhibit 15, and in the said exhibit, I have reflected that both the accused persons were, at that relevant time, traveling with another non-tribal in the said auto rickshaw. But merely traveling with a non-tribal does not mean Biplab. I did not show the photograph of the deceased Biplab Das nor his wearing apparels to the driver of the said auto rickshaw to verify who is the non-tribal traveling together with the accused persons at that relevant time. I did not record the statement of the accused persons leading to the discovery under Section 27 of the Evidence Act for seizure of material exhibit 2, the rope, which was recovered on the leading of the accused. The witnesses reflected in material exhibit 16 with regard to seizure of material exhibit 2 are all police personals except for one Shri Deepak Das, PW 18, who was the driver of a vehicle requisitioned by the police on that day. I have not recorded the statement of these witnesses of exhibit 16 to reflect that the discovery or seizure of material exhibit 2 was at the instance and leading of the accused person. I have also not recorded the statement under Section 27 of Evidence Act with regard to the leading of the accused person to the discovery of the dead body of the deceased. It is not a fact that my statement that it was on the leading of the accused persons which led the discovery of the seizure of the dead body and also the seizure of material exhibit 2 is only my imagination. I did not record the statement of accused Shri Boni Bhawa leading to the spot of where the dead body was lying. My lord, Boni Bhawa never led to the spot where the dead body was lying only, so how can he say that?
Correct.
I do
According
not...
to the prosecution case, Boni led to the murder weapon, Bernard led to the dead body.
My lord, but here the IU is saying that Boni has
We
led.
followed. Carry on.
I do not know if the deceased Biplab Das has married PW6 Nirvika Singhania against the wishes of her father. I do not know if the deceased and PW6 were students of St. Anthony's College. My lord, this part is very important. According to my investigation, accused Boni Bhawa has been implicated by accused Bernard Lingdo Bhawa, but I did not try to find out if there is any family hostility between these two as they are related. This is one very material aspect, my lord, because Boni was never there. Boni was never there. It is Bernard who has pulled out Boni.
Boni has made a statement that he died on my lap.
My lord, that is a statement under 164 which cannot be relied upon until and unless corroborated
That
by
will get him the news.
evidence.
That will get him the news.
Until and unless corroborated,
That will
my lord.
get him
There is
the
no
news.
corroboration.
It's a judicial magistrate that you're talking about. Requires no corroboration.
Lord,
Yes.
164, in my humble
Requires
submission,
no corroboration. It may be circumstances point to that, and that's the admission. And the proof of the pudding is in the eating, because he not only says died on my lap, suggesting it was of natural causes, but the fact remains that whoever may have pointed out to the body, even if the murder weapon is not discovered, the death was unnatural, death was by strangulation.
my lord, that is no doubt true because the postmortem clearly proves that. But that is absolutely contradictory to the statement under 164. So
Whose statement under 164?
Boni's statement.
Yes. So therefore, if Boni admits that the person died and the cause of death given by Boni appears to be completely, contradicted by the forensic scientific report, then Boni has to carry the baby.
My lord, that will come only when the prosecution proves the case beyond reasonable doubt.
That is
Here,
proof
my
beyond
lord,
reasonable doubt.
the postmortem
That
report
is proof beyond reasonable
My lord,
doubt.
the postmortem report says 48 hours.
Oh, you can
They
harp on
say-
that,
they say-
You finish that, we have
96
disregarded
hours.
that.
Statement last seen
You have to, all of what you're doing is, you're doing of what happened before Mauro.
My lord, this entire case is a
What
case of
happens at
circumstantial.
Mauro is what is important. What happens before Mauro is utterly irrelevant,
there is
because
no-
even kidnapping case has not been made out.
My lord, in fact, no case only has been made out.
Carry on.
Neither murder nor
Carry on.
kidnapping.
We are convinced murder.
My lord, somebody else might have done it. It was a public place. He was drunk.
You have to point out a
He was
theory.
drunk.
You have to point out a theory.
My lord, he was absolutely drunk.
How are you getting the fact that he was drunk?
My lord, that is according to the statements of 164.
So
Absolutely
that part of
drunk.
the statement is correct. That Biplab was drunk. But the other part of the statement that he died on my lap is incorrect.
The entire 164, my lord, it has never been recorded only. With regard to Bunny.
That is almost contumacious. You are accusing a judicial magistrate without cross-examining her, without attributing any motive to her. Only in your 313 you withdraw.
Substantially, she was aware of the entire facts and
May have
circumstances
been.
of the
May have
case.
been. So
she was well aware.
may have been. We are aware of the circumstances in which illegal coal mining is going on. Are we not taking up the bill matters of the same persons?
Indeed, my lord.
Then that's our job. And we're talking of the year 2006.
But both the things were done in course of her duty only, in course of her job.
Yes.
The inquest was also in
We're
the
talking
job.
of 2006. How many judicial officers were available in Meghalaya in 2006?
Lord, I am not aware about that.
Then reflect on that. How many judicial officers were available in Meghalaya then? We're talking of 7 years prior to the High Court being set up.
Yes, my lord.
There were hardly any judicial officers. By the doctrine of necessity, she was required to do both things. Do you think that they would have, anyone in her senses would have done both if there was a choice available?
But she stated, the learned judicial magistrate stated that there is no bar in recording the statement.
Yes, there is no bar in recording the statement. Like there was no bar in our taking up anticipatory bails in matters where we have said, go look for the kingpins and put them behind bars. We have said that. We've also taken up anticipatory bail. That's part of our job. But we have no personal interest in the matter, just like your attributing motives to a judicial magistrate who is not present over here, who you've not even questioned, who you have not attributed any motive in the trial court.
Motive we can
Must be very
definitely not
careful.
attribute, my lord. Motive in the case of a person.
Why should a judicial officer
There is no
falsely
reason.
implicate you?
There is no reason to falsely implicate.
Then-
But my lord, both the
Your allegation is that I did not make any statement. She wrote out a statement out of her imagination and presented it. If that is correct, why will she write a statement which is different from, we'll tear you apart personally for this. The insult that you are heaping on the judicial officer, if you find our judgment heaping the same insult on you,
my lord, I'm
we
repeatedly.
are telling you that. Why will she not choose the shortcut of taking Bernard's story and saying it through Bonnie's mouth? The statements are different.
But my lord, the documents need to be in accordance with.
The documents need to be, very well, she was careless. We'll accept that. She did not sign every place where she ought to have signed.
The
She
dates
should have been
also
more
tally.
careful. But that does not mean that she's a liar. That does not mean that she's making up a story against you.
But my lord, the dates also do not tally.
May not.
My lord, in every single instance,
What every single instance?
my lord,
Every single instance, we can tell you how much your right hand is lopsided against your left hand. But it is irrelevant for the matter.
my lord, seizure list also, there is a drastic difference.
So what?
Statement of witnesses also, there is
In
drastic
which
difference.
season is there a drastic difference?
Seizure list, my lord, I had taken your lordships to Exhibit 3, seizure list.
Which, what is that Exhibit 3 is about?
Exhibit 3, page number 409. My lord, the PCO bill. PCO bill being seized. The witness has signed in the month of April, whereas the seizure was in February.
We'll note that. You come to that. You have not made that point yet.
I had, my lord.
No. You come in.
My first point was that, my lord.
No. You have not shown those to us.
I have, my lord.
No. PCO bill you have not shown to us.
My lord, not the PCO bill. I'm talking about the seizure list, my lord.
No. You have.
Seizure list.
No. You have indicated that, but you will definitely come. All that you have done covered now is statement under 164, Nirvika Singh, which we said nothing against you, except the fact that then you've gone on to postmortem report, then you've gone on to murder weapon, now you've come to IO. But you have
Then
not shown us.
after IO, I will again
that.
show that.
But don't jump. The thing is not the PCO and those exhibits have not been recorded by the judicial officer. We are talking about the judicial officer. We accept that she was careless, that she should have put the date on every page, she should have been more careful, but that does not mean that she imagined or invented the statement, which is what you are trying to tell us, which is what not even your client accused her with, except at the 313 stage.
Lord, 313 is the stage where the accused is questioned.
And when the witness is available before you, you keep mum.
My lord, there also the question was put.
That it's an imaginary statement that you've recorded.
That the statement was recorded, the statement has been modified subsequently to that effect.
Modified subsequently is admission of the statement. Please do not treat as a student.
Not at all, my lord.
Modification means admission. Please get your mind right. You're doing a criminal trial before the highest court of the land.
Indeed, my lord.
Modification does not mean invention. Modification does not mean fabrication. Modification is admission and then alteration.
Now, if your lordship permits, may I continue with the cross, my lord?
Yes.
We were at paragraph 3, my lord. PW6 Nirvika Singhania in her 161 statement has stated that the deceased Biplab Das rang her up on 18th February 2006 in the night time, telling her that he was with two of his friends who came from Siliguri and one of them is named Sumit. I did not try to find out who are those people who had come from Siliguri who were with the deceased on that day. According to the investigation, the last call made by the deceased was to PW6, but I have never seized the mobile phone of PW6. I have also arrested one Akbar Qureshi, but I do not know if he is also charge sheeted in this case. By Exhibit 12, I have seized one mobile phone, Material Exhibit 6, from the house of PW11 Shri Ayub Kharkonkar, which according to my investigation, the said mobile belongs to the deceased Shri Biplab Das, which has been identified by the friends of the deceased, but I have not recorded the statement of those friends of the deceased who have identified this mobile phone Material Exhibit 6. Neither have I shown Material Exhibit 6.
Over here once again.
My lord.
Mr. Khan has stressed on this aspect
My lord.
of both the husband and wife statements, that how it was recovered, the phone and things like that.
My lord, the cross was not taken.
Yes, and we somehow thought that there was something doubtful about it. So you have to eliminate this. This is one of the things that you have to eliminate.
My lord. Material Exhibit 6, neither have I shown Material Exhibit 6 to the father of the deceased. Material Exhibit 35 and 36, which are spectacle and a wristwatch seized by me, belongs to accused Shri Boni Phawa.
What is the relevance of 35, 36?
Relevance is this, my lord. At the time when the seizure was made, the prosecution made a statement that this spectacles and wristwatch belong to the victim. But here in the cross-examination, he is admitting that it belongs to Boni Phawa himself. Exhibit 14 is the seizure list in respect of a purse. I did not try to verify through any of the witnesses as whether to whom this purse belongs to. Accused Bernard Phawa was arrested on 20th February 2006 while the other accused, Boni Pawa, was arrested on 23rd February 2006.
Pausing here for a moment.
My lord.
Was it not on 20th February that Bernard went looking for?
It was on 19th,
It
my
was
lord.
on 19th. Very good.
19th, he went looking. In the evening, the police had taken him in for interrogation. And on 20th early morning, he was...
When was it that Bernard was identified by the PCO man as being one of the persons who had come the previous night? That was on 19th itself.
Watch please.
Yes, my lord.
That was on 19th.
19th night, after lodging of the FIR, my lord, this group of friends again went to that particular area to search. And it was at that point of time that the PCO owner had told that friend of Biplab,
Roger. Told Roger that.
Told Roger that this person had come the previous evening, but he told not to disclose it to anybody.
Yes.
It is not a fact that accused Boni Pawa was arrested when he came to surrender before the court. Accused Akbar Qureshi was not sent for recording of his confessional statement by the court. Though I have...
Tell us, how did they get to Boni?
My lord, that is what is here. It is at page number 325, the second paragraph.
Where?
The fourth line, my lord. Second paragraph, fourth line. According to my investigation. My lord, the paragraph which starts with I do not know.
No.
That is how they got hold of...
Something else.
Bernard had taken the police to the house of Boni.
They found something incriminating.
No, my lord. It is clearly written here. According to my investigation, accused Boni Pawa has been implicated by accused Bernard Lingdo Pawa. But I did not try to find out if there is any family hostility between these two as
That's
they
all
are
right.
related.
That's all right. But on what basis was Boni arrested?
On the
There is
basis
some
of the
evidence.
statement-
There is some evidence of Boni
Yes, my
being
lord.
questioned
They had gone
about
to the
the
house.
missing phone, and then Boni
Yes,
saying
yes, my
that
lord,
he
I'm
had
coming to
sold
that.
the phone to that
I'm coming to that, my lord. The phone
Contempt.
seizure. My lord, a raid was took place at the residence of Boni Pawa, and in the said raid, the Darbar Shnong secretary was one of the witnesses, the Rangbadong was one of the witnesses, and seizure witness of phone was PW21.
phone was found at Boni's place.
It was found in the residence of Mr. Khatun.
It was found in the residence of Khadunkar.
In fact, my lord, the
And his
phone-
wife said that it had been given to the husband
But-
by Boni.
But this has been disproved by us, my lord, in the evidence. How, my lord? Because at the time, in 2006, the procedure to recharge a mobile phone was through scratch cards. So they could not recharge the mobile phone of Biplab, and the local guardian and the friends were not being able to reach him. Subsequently, in one of the depositions at page number 90, it is found out that the phone of Biplab was with David Gomes and that of David Gomes was with Biplab. But the local guardian says that he does not remember whether David mentioned this particular aspect to him in the morning, in the afternoon when they were out for the search of Biplab. So, my lord, actually the mobile phone of Biplab was not available with him only. It was with David. And that is very much there in the form of a deposition at page 90.
So, the phone recovered from Khadunkar was
Boni's
David's.
phone.
Was David's.
No, my lord. It was Boni's phone. Boni had given it to Ayub Kharkongor because he was in need of money and he wanted to sell it.
His own phone.
Yes, my lord.
No,
And Ayub Kharkongor has been,
we've read Boni's statements.
My lord,
The 164 statement itself
my lord, phone part.
is not there in 164.
no,
We've
my
read somewhere.
My lord, it is there in Ayub Kharkongor's statement. Just see.
Anyway, he has just finished this.
Accused Bernard Pawa was arrested on 20th February 2006, while the other accused, Boni Pawa, was arrested on 23rd February 2006. It is not a fact that accused Boni Bhawa was arrested when he came to surrender before the court. Accused Akbar Qureshi was not sent for recording of his confessional statement by the court. Though I have stated that I have recorded the statement of accused Bernard Bhawa and Boni Bhawa before the headman Sri Shankarlal Singhania, but I have not recorded the statement of Sri Shankarlal Singhania. My lord, Shankarlal Singhania is the headman. He is the headman of Police Bazaar. At that point, till
But not related to Nirvika.
Might be, my lord, we don't know.
Very well.
It is not a fact that I did not record the statement of Sri Shankarlal Singhania as because no statement was made by the accused in his presence. I do not know whether Shankarlal Singhania is related to PW6 Nirvika Singhania. Neither did I make any efforts to find out. I know one Sri Dwarka Singhania who is a supplier to the police department, but I do not know that he is also the uncle of PW6. Exhibit 1 is the PCO bill, which I have seized from PW1. It was not from the PCO itself, it was from PW1, my lord. I cannot say how the PCO bill is in the hand of PW1. He might have collected it from the PCO. I did not examine the owner or anyone else of the said PCO. I did not try to find out as to why the deceased, who was having material exhibit 6, the mobile phone, had to go to a PCO and ring up Nirvika Singhania, PW6, from the said PCO as stated by PW1. It is a fact that the person who knows about the deceased Biplab Das' last whereabouts is PW6 and her family, but except for PW6 Nirvika Singhania, I did not examine her other family members. I do not know that PW6 had made a documentary film in her college about her marriage between a Marwari girl with a Bengali boy, and the hero of that film was the deceased Biplab Das, and in that film the hero was shown to have been killed by the parents of the girl. It is not a fact that PW6 and her family were involved in the missing of the deceased Biplab Das. It is also not a fact that to protect them, I have falsely implicated accused Bernard and Boni in this case and try to project that they have been demanding ransom from the family of the deceased. If I may pause you for a moment, my lord. If at all Bernard and Boni wanted to kidnap Biplab for ransom, then they would definitely not kill Biplab. Secondly, 164 statement clearly says that Bernard and Boni tried to rub the feet of Biplab. Lord, if they would at all have the intention to kill Biplab, why would they rub the feet of Biplab? That makes no sense at all.
What are you saying?
My lord,
The golden goose has died.
my lord,
Did you not try to save the golden goose?
rubbing the feet means they did not kill him.
Rubbing the feet means they did not kill him.
My lord, because if they would have the intention, why would they try to save him?
Oh, rubbing the feet means they would not want to kill him.
Definitely, my lord.
Very good.
So killing nowhere comes here.
If Chandrayaan has gone to the moon, the Sunil Gavaskar did not ever score a century.
My lord, that is another context.
Yes. No, that's the link.
My lord, I apologize if here and there.
How? Please be conscious of what you're saying. You take a person and he is your goose that lays the golden egg. Somehow, in the heat of the moment when you are all drunk, we don't know what, we were not there, you throttle him. Then you think that he could be dead. You don't throttle him with the intention of killing him. But you find that he's not moving around, he's not showing any signs of life. You try to revive him. Because he will lay the golden egg. If he is gone, there is no golden egg to look for.
But my lord, the ransom call is said to have been received on 19th.
You are jumping from something to something.
My lord,
You're jumping. first let us take the absurdity of what you're saying. So this has no, whether they wanted him dead, no one is saying that they went about in a premeditated manner. But once the death has taken place, it's an unnatural death. Then it is for them to admit, yes, it was accidental. We plead guilty to a lesser charge. Once they don't, because they were the only persons over there, then we have
That is
to
only
accept-
on the basis of 164.
only on that's good enough. It is before a judicial magistrate.
But my lord, the circumstantial evidence, the entire chain of circumstantial evidence,
Forget the chain of circumstantial
has
evidence.
nowhere been.
They admit they were there. Forget the circumstantial evidence. Nothing else is necessary.
Lord,
All of the rest is irrelevant.
then, my lord, the trial itself, if your lordship is saying that the
The
entire
trial
thing
court
is.
went completely wrong. The trial court looked at the wrong things.
But, my lord, the trial court has seen every material aspect of the evidence.
May have been. May have been.
And evidence
Now,
is the most important.
if you're talking about, something which is, you have to sift the essential from the irrelevant. And there lies the art. The trial court failed in that art. That's why we are sitting here to correct it.
My lord, but the trial court's judgment, in my humble submission, my lord, the trial court has dealt with every single evidence.
They have, but wrongly, erroneously.
In my humble submission, my lord, it has not been done erroneously or irrationally
That's
or
why
in
you're
any
standing there.
unreasonable
That's
manner.
why you're standing where you're standing. That's for you to suggest that.
My lord,
But we are saying, even if you go by what has been shown, last scene,
last scene is also, my lord, they say
nothing.
There is
The
no
relevant
last scene.
considerations have not gone into that.
My lord, the
She's not even
circumstantial,
considered the 164 statement.
but my lord,
She's not given a good reason to discard the 164 statement.
Lord, if we read that, we'll get to know whether it is reasonable or unreasonable.
We read it. We read it today. Nothing over there is any basis to discard the 164 statement. She's done the last scene theory without going to the 164 statement.
Lord, but then the 164 statement has duly been taken into consideration and thereafter a judgment has been passed thereon.
Yes. On what ground has she disregarded it? We'll come there later. You finish this, we'll come there later.
My lord, it is not a fact, my lord, I've read this paragraph already. It is a fact that the call for demand for ransom was sent to the father only after the death of the deceased. I cannot say why the media, PCN and others were allowed to conduct the videography of the exhumation of the dead body of the deceased when the police department have got its own videographer and cameraman. I did not seize the videography, but the same was done by Inspector PCM. The second IO, my lord. I have seized material exhibit 4/1, which is the laptop of the deceased, but I did not try to find out what the laptop contains. I have seized material exhibit 4/1 from PW5 Shri Binoy Das on being produced by him. I do not know how PW5 Shri Binoy Das came into possession of material exhibit 4/1 when he has come from Siliguri. I had visited Yak restaurant situated at Umsosun along with accused Bernard Pawa to examine the owner and staff of the restaurant, but he could not identify anyone. No TIP was held in this case. My lord, this restaurant is that very restaurant regarding which in 164 the accused persons are saying that they went to a restaurant in Umsosun.
No one identifies.
No one identifies, my
Very
lord. So,
good. There are so many people who go to a restaurant, there are so many drunkards who go to a bar. Will you remember after 4 days, 5 days, 6 days? You can remember maybe the next day, you can maybe remember a few hours later, particularly when you're taking no notice. If something unusual happens, say for instance, the two of them have a fight in the bar,
yes, my lord.
of course you will. If nothing unusual happens, you may be the waiter at the table, you may be the owner, you may be the person sitting at the counter making the bills and keeping an eye. But if nothing unnatural happens, you do not, the imprints of the faces are not in your mind. Your mind is attracted to incidents that excite you, incidents that leave a mark on you. So if two persons have been fighting, surely you will remember because you would have tried to stop it or you would have witnessed it, you would remember the two faces. But if two people come, have a drink, or three of them come, have a drink, and then go out, it's not possible for the bartender or any waiter or any other to remember. It's possible you may remember. There could be a slight incident, you may have dropped a glass, and he may have picked up the glass and said, "Oh, are you hurt?" So this is a kind man, you remember that. But if nothing, spectacular or nothing eventful happens, then you tend not to have a visual recollection to the extent of being able to identify. Now that is what the test you'll have to apply from the perspective of the trial court judge, because what are we doing? Neither you nor Mr. Khan nor either of us was anywhere remotely close or connected to any of these incidents. We are getting second-hand, third-hand reports. We are getting accounts from which we are using our intelligence to assess whether this was a possibility, whether this was a certainty, whether this could have happened this way, whether this could have happened any other way. So we will also, all of us will be making errors. None of us will be perfectly right. In my imagination, through my intelligence and my prudence, I may be visualizing it happening in a particular way.
Yes, my lord.
But even if you agree with me, your vision of the incident is going to be completely different from mine. It's not going to be identical. Even if you fully agree with me as to how it happened, whether he boxed in from the right, or whether he ducks on the left, or whether he vomited first and then started speaking, or was vomiting while trying to speak, all of these, the imagery that is created differs from person to person. So what is important out of all of that is, through our second-hand, third-hand, fourth-hand backdated knowledge, is whether this is how the essential part was played out. And if we are convinced that that is how the essential part was played out, the rest become irrelevant. Yes.
It is not a fact that my investigation was faulty and influenced. It is also not a fact that due to this faulty and influenced investigation, I have let the real culprits get away with the crime. My lord,
So therefore, madam, there is a possibility over here of a conspiracy theory against the family of
my lord,
Nirvika.
my lord,
But neither have you furthered that. We are not an American system.
my lord, that has come in the cross-examination.
We are not an American system.
Yes,
In
my
an
lord.
American system, the
Inquisitor.
lawyer engages detectives
Yes, my lord.
to find out and produces that incriminating evidence to cast a doubt. We don't have that system. But over here, just merely saying that's a possibility won't do.
But
There has
that
to be
is there in
something
the
else.
evidence.
That's neither here nor there.
That is there in the evidence.
That's neither here. You could have instead of that said that maybe a Martian came and killed him. The question, the effect of that question is the same. If you ask, maybe a Martian came and killed him.
It was clear whether they tried to inquire from the parents
So
and
there's
family
something
members.
else you could have got. Some other material you could have got, something else that you could have questioned the investigating officer with, or something incriminating against another person where we would have thought there is a possibility. But only just one question.
My lord, going to PW 34, the second IU.
PW 34, yes.
I'll take your lordship to the cross-examination, which is at page number 334.
334.
My lord.
Yes.
It is a fact that I also have taken part in the investigation of the instant case. During this relevant time, I was serving as the OC of Sadar PS Shillong. SIBC Thakur was endorsed with the investigation of the instant case, and the same was done under my supervision. On receipt of the information Exhibit 2 in this case, I have registered it under Section 364A IPC. Though Exhibit 2 does not reflect the existence of any ingredients of Section 364A IPC, but the inquiry done by SIBC Thakur PW33 reveals the offence under Section 364A IPC. We have also spoken to the father of the deceased victim the moment the FIR was received, but we have not reflected this in the CD. Neither the report of the inquiry conducted by PW3 was reflected in the CD. It is not a fact that my statement today that we have spoken to the father of the victim is just an afterthought. The investigation reveals that the call to the father of the victim, Shri Binoy Das, PW5, was made from Guwahati. I visited the PCO at Guwahati from where the call was made and recorded the statement of the owner of the PCO, who stated that being a PCO, he cannot exactly remember the caller who made a call to PW5. I did not show any photograph of the accused to the PCO owner so as to help him recollect the caller of the call. Neither any TIP was held. It is not a fact that I made no efforts to find out the caller who called PW5, and it is also not a fact that I made no such efforts as because the accused never made that call. The call from the PCO was made to PW5 Shri Binoy Das on his mobile, but I have not seized the mobile phone of PW5. It is not a fact that I did not seize the mobile phone of PW5 as there were no such calls made to him. During the investigation, one person by the name of Akbar Qureshi was also arrested in this case, but he was not charge-sheeted as there was no evidence against him. But the reasons for not sending the said Akbar Qureshi for trial was not mentioned in the charge sheet by me. The accused...
This Akbar Qureshi and the Cardinal, they are the same person.
No, my lord. The accused Akbar Qureshi is also a resident of Shillong. Accused Akbar Qureshi was sent to the court for recording of his statement under Section 164 CRPC, but he declined. My lord, here is the contradiction. PW 33 says that Akbar Qureshi was never sent to court for recording of statement under 164.
Madam, there was a bird on the tree at that time. How is it relevant for us?
But my lord, the two
How is
IOs...
it relevant for us?
The
Have
two
we
IOs
said
are
anything
contradicting.
about? Have we said anything about Qureshi?
But
Are we taking anything about Qureshi into account?
we are taking into account the investigation made, and both the IOs, when PW 34 is saying that the investigation was being done under my supervision, so the statements of the two investigating officers in my humble submission, lordship, should not contradict, and here it is an absolutely contradictory statement.
Anyway, proceed.
It is a fact that accused Akbar Qureshi has also... Sorry, this para is over. It is a fact that PW6 Nirvika Singhania's parents are also having a furniture workshop, but I do not know that accused Akbar Qureshi was working in this workshop as a carpenter. Before filing the charge sheet against the accused person, I had gone through the materials on record, including the confessional statement of the accused persons. It is correct to say that accused Bernard Lingdop Hawa has stated in his confessional statement before the court that the deceased victim married PW6 Nirvika Singhania against the wishes of her parents. I did not pursue the investigation of this case on the line that the cause of death of the victim might be due to his marriage with PW6, which is against the wishes of his family. The material Exhibit 6, the mobile phone, was seized by me from the house of PW11 Shri Ayub Kharpongor, and material exhibit 6 belongs to the deceased victim. Lord, he's saying so, but I'll substantiate by going to PW11. Material exhibit 6 was seized on the leading of the accused Bonnie Lingdop Hawa. I did not try to confirm from any of the victim's friends or relatives whether material exhibit 6 belongs to the victim. It is not a fact that material exhibit 6 belongs to accused Bonnie Lingdop Hawa. Now, my lord, he has again changed his statement.
Where does he change his statement?
Sorry, my lord, my misunderstanding. It is not a fact he has stated.
It may be an erroneous statement, but he has not changed his statement.
The statement of accused Bonnie Bhawa was not recorded during the seizure of the material exhibit 6 on his leading, but accused Bonnie Bhawa disclosed about this material exhibit 6 during his statement under section 161 CRPC recorded prior to his arrest. I have not recorded the statement.
Is Bonnie is 161 available?
Not in the paper
Not in the
books.
paper book.
Not in the paper books.
Very.
I have not recorded the statement of the accused Bonnie Bhawa in presence of any witnesses while he was giving his statement regarding the discovery of material exhibit 6. Material exhibit 2, the rope, was seized from an open space near the graveyard where the victim was buried. After the arrest of accused Bernard Bhawa on 20th February 2006, it was revealed that material exhibit 2, the rope, was used in the killing of the victim. About how was it revealed? We don't know. Nothing is stated. The dead body of the victim was recovered on 21st February 2006, and material exhibit 2, the rope, was recovered on 24th February 2006. While visiting the PO on the 21st of February...
Now, PW 25...
26...
PW 25 and PW 26.
25, 26, 18.
No, 25 and 26 have indicated 24th February.
Yes, my lord.
18, of course, says December. 18th
Yes, my
December.
lord.
Yes.
While visiting the PO on the 21st February 2006, I made all efforts to find out and recover...
Stop, madam, after you completed this point. We'll stop.
My lord.
Yes.
And recover any incriminating materials from around the PO, including the rope, even the shoes of the deceased victim, but I could not at that time. It is not a fact that material exhibit 2, the rope, was subsequently planted by the police at the PO to implicate the accused. My lord, no section 27 statement is there.
We are aware of
Nothing
that.
is there.
We are aware of that. That's the admitted position. That's why we disregard the rope. Anyway, continue. Whatever else you want to show of the evidence.
My lord, the cross by Bonnie is just ending in the next two
Yes,
to
yes.
three paragraphs. Ma'am. The originals of paper mark 1, which are the PCO bills, were not seized except the photocopies, which are paper mark 1, as because the proprietor of the PCO needs the original in course of his business transaction, but I have not reflected this reason at the time of seizure of paper mark 1. I also did not instruct the PCO owner to retain the original copies of paper mark 1. The owner of this PCO is also cited as a witness in this case, but my lord, he was never examined.
No, but which PCO is he talking about?
Guwahati.
What PCO? Not the
Not the one here, my lord.
not the one here.
It is not a fact that the parents of PW6 were responsible for the murder of the deceased victim, and it is also not a fact that the parents of PW6 murdered the victim due to his marriage with PW6, their daughter, which they did not approve. My lord, how can he be so sure that it is not true when they did not even try to find out whether the parents were involved or not? It is
How
also...
can you make a wild accusation? You made a wild accusation, he's given a wild reply.
But my lord, he is deposing on oath.
So, and you are also hopefully questioning him with some responsibility.
Yes, my lord, because in the previous statements they have themselves stated they did not make any
Irrelevant.
effort.
If you could have shown that there was some other material, if you may have called a witness or in course of any of the evidence, you had shown that no, Nirvika was actually with Biplab at any time when she says she got a phone call, it could have shown some kind of, deviation. But there's nothing that you show.
Nirvika's
You just
deposition.
make a wild allegation against the family, nothing else. Yes.
The Nirvika herself has deposed that she received a call from Biplab saying that he was with Sumit.
Yes.
So, my lord, a friend will most probably not lie. And especially in these circumstances when the rumor is that they were married. We don't know whether they were married or not.
Let us see. Yes.
It is also not a fact that to safeguard the parents of PW6, I have not given sufficient evidence against accused Akbar Qureshi, who is their worker. It is not a fact that myself and PW33 SIBC Thakur have not conducted a proper and thorough investigation in this case. It is also not a fact that I have falsely implicated the accused persons in this case. It is also not a fact that I filed a charge sheet against the accused in order to allow the real culprits to get away. My lord, these nowhere prove that Boni had killed Biplab in any way. Neither the kidnapping has been established, nor the murder has been established,
Absolutely
nor
correct.
201 has been established.
Absolutely correct.
Nothing has been established, my lord, from any of the evidence.
Absolutely correct.
And the FSL report also, it is
Nothing.
categorically- There is nothing in the FSL report
Nothing.
which shows that, my lord, there is one more aspect to this matter. The prosecution is saying that a coconut rope was used for the murder. My lord, a coconut rope is kind of tricky. If a person is strangled with a coconut rope, small pieces or small strands of the coconut rope will get into the skin. The victim was sent for post-mortem examination. But my lord, nothing of that sort has
There
been
is
found.
something to the effect that possibly plastic rope or something.
It is just simply stating blunt rope.
Yes.
But what has been recovered is a coconut rope,
Very
and
good.
which has
Madam,
been sent for FSL.
are you an expert on coconut ropes?
No, my lord. But
So there are
We
many
have-
things that you need to know. A newly prepared coconut rope is very prickly. If it has been used
Old
for
one is
quite some
soft.
time, it becomes soft. If you dip it in water, it becomes almost very comfortable to deal with. Now we are talking of the month of February, we are talking of the evening when there is dew, we are talking of the damp grounds of a cemetery. So, all this that you say may impress some others, but when you keep your mind open to the other possibilities, then the fact that there is no prickly residue of the coconut rope,
Lord, this
unless you can scientifically prove to us that every time a coconut rope is used, it will leave some prickly residue on where it has been
Lord,
used.
there is a second aspect to the rope as well. The rope was sent for FSL
No, DNA, no blood.
1 month after its recovery.
That's why we
And
disregarded that.
the FSL says
We are
that
telling you over and over again, we are not treating that to be the murder weapon.
my lord,
Murder weapon not found.
my lord. Then, my lord, whether
But-
it was a murder, how?
but
There is a big question
You
mark.
say, no question mark at all. You say he died in your lap. So strangulation, your failure to explain gets you the news.
There is just
There may have been no
one,
coconut rope, but you get a greater quality rope.
just one judgment, my lord, if I may be permitted to cite.
Right now, we'll begin when we begin the next day.
My lord, tomorrow, as
I
the
don't
date
know
had been
whether it's
fixed, my lord.
possible or not.
Lordship had stated 29 and 30.
Or we'll fix it tomorrow.
Yes, madam.
Then we'll continue tomorrow.
My lord.
You're still hanging on, Mr. Khan. She has to come to the main point to dislodge you. She's nowhere near that. This will go as part of wherever you're keeping the judgments. Please put this in a file.
Please take note.
You will continue immediately thereafter. No, we are asking you.
The main issue, my lord, is whether the 164 is enough to.
164 is?
Whether the 164 is sufficient evidence to.
When there is nothing else, 164 is. Keep this in a file, please.